Good morning. I'm Father X, talking about how fathers can win their child custody case. In this episode, we're going to talk about the overall timeline and process of a custody case in family court. Let's get to it. Why does this matter? The numbers clearly tell us the odds are against the father when it comes to child custody after a divorce or separation. To get through your custody case, you have to understand the timeline and events of the family court process and how the game is played. And you have to proactively prepare and plan ahead to manage each step of the process. If you're just reacting to everything that gets thrown at you, then you're more likely to get steamrolled. I'm giving you an example of a live case, using my case, so that you can see the reality of how things can work in family court. In episode 6A and 6B, I discussed my first day in family court. Remember that in the real world, before court happened, I was a victim of the mother's domestic violence, and the mother was suicidal, had severe anger management issues, threatened to kill our unborn child with a kitchen knife, and was floating between bipolar and borderline personality disorder. And remember that after 40 months and a full trial, I was ultimately deemed to be the parent more fit to raise our son. So here's the court process on how we got there. On the first day of court, the referee ignored the total set of best interest factors and issued temporary custody to the mother only because the mother was unemployed and available. The mother was given custody 5 nights every week, and I was made a weekend dad from Friday night to Sunday afternoon. At the end of that first hearing, the referee ordered a Child Protective Services investigation to evaluate the issues of domestic violence and the home environment of each parent. The referee didn't make any effort to understand which parent was committing domestic violence, but instead outsourced that to a social worker at Child Protective Services. That Child Protective Services investigation took place during August and September, when the social worker visited me and the mother separately in our homes. At the end of September, we went back to court for our second day of court, but this time we had a new judge. This judge was overseeing the false criminal allegations against me, as well as the custody matter. Of course, this new judge didn't know anything about me, the mother, or our son, and obviously didn't know the criminal allegations were fabricated by the mother. In court, in the morning sessions, approximately 20 other sets of parents are there to have an appearance before the judge. So every couple gets approximately 10 minutes each on average to talk to the judge. Basically, these appearances become a speed contest where there's no intelligent thought about the best interest of the child, if there's any thought at all. In the afternoon sessions, there are 2.5 hours devoted to one custody trial at a time, where the lawyers are questioning and cross-examining the witnesses, and each side is presenting evidence. During the trials in the afternoon, you, your ex-wife, and the court employees are generally the only ones in the courtroom. Every state and courthouse can have different processes on how they do this, but I'm giving you one real example so you can then figure out exactly how this is going to work in your case, in your courtroom. In late September, we had our second appearance, but with this new judge. And in this episode, I won't get into the details of all the statements made in court because it would take too much time, but I'll discuss that in a future episode. I recently read our court transcripts again for purposes of this video, so I'm not just stating these things from memory. In this September appearance, the Child Protective Services investigation was allegedly completed, but nobody knew where it was, nobody read it, and the court had to go find it for the next court date. My lawyer and I also asked the judge to give us 3 nights a weekend and alternating Wednesdays, because I changed my job schedule and was available to parent on Fridays. I took away the excuse that the referee had on the first court appearance. But the judge ignored our arguments and continued to rubber stamp the mother for primary custody, pending a trial. So I learned that without a trial, default primary custody goes to the mother. The court also decided a guardian ad litem attorney for the child wasn't necessary because he was less than 1 year old and unable to speak. In October, my criminal lawyer arranged for me to meet the district attorney's office. This meeting was called Queen for a Day, where we had a confidential meeting without the mother to discuss the facts of the case with the DA to see if they would dismiss the charges. I think the 2 district attorneys showed up thinking This was a case where the woman is a victim of domestic violence and everybody can turn off their brains. We met for 2 hours where I introduced the DA to the actual reality of the circumstance. After that meeting, the district attorney had to go think hard about their case against me. I'll give more details in future episodes when I discuss criminal allegations. Before I continue, please like, subscribe, and share. Also, if you find this information helpful and you want to support this channel so I can make more videos, please donate via my YouTube channel's About page. You can donate via PayPal or Venmo. In early November, we went back to court. In my first appearance that day, it was the district attorney versus me, with my criminal lawyer in front of the judge. It was just about 5 minutes long because the DA dismissed all the criminal charges against me. But I wanted the DA to file criminal charges against the mother for lying in a police report, and the DA refused. I learned that if a mother files a police report, then the police and DA act quickly to arrest the father. But when the father wants to have the mother arrested for lying in that police report, everybody in the legal system runs away like a coward. When that 5-minute session ended, the district attorney left, and I stayed in front of the judge. The mother was called up to hear the case of the mother versus me in the child custody and the order of protection matter. This time, we finally had the Child Protective Service's written report. But the social worker was unable to figure out who the perpetrator of domestic violence was, so that whole exercise proved useless. Then my lawyer again asked the judge for equal parenting time, noting that in the court-ordered investigation, the mother admitted she threw a bottle at the father's head in anger, and the mother admitted she took a knife during her pregnancy and placed it to her stomach, saying she would end the pregnancy. So those bad facts were confirmed. But the judge ignored the negative evidence against the mother and continued to rubber stamp her for primary custody. The judge started talking about the idea that we would need a forensic evaluation by a third-party psychologist in order to proceed with a trial. The judge asked us to talk in between court dates to see if the parents could settle the case or if we needed to move forward with forensics and a trial. In late November, we had another 10-minute court appearance. My lawyer asked for more equal parenting time for me, and again, the judge refused without providing any intelligent reason, just saying that she was going to wait until a full trial. So again, the mother is rubber stamped unless there's a full trial. We all agreed that we needed to move forward with a forensic evaluation and trial. The judge asked each side to produce 3 names of potential forensic evaluators, along with the cost of each evaluator. And each parent had to recommend what percentage of the evaluator's fee each parent would have to pay. In December, we submitted that information to the judge in writing. In early January, the judge emailed us her decisions that, first, the forensic evaluator would be one of the evaluators that the mother's lawyer suggested. Second, I requested we split forensic costs 50-50, but the judge sided with the mother and decided I should have the majority burden, paying for 85% of the cost, which turned out to be over $25,000. Even though neither parent could afford it, the judge gave 85% of the financial burden to the father. Later, in January, we had another 10-minute appearance where we confirmed that we received the forensics order and that we each already set up appointments with a psychologist. Also, my lawyer asked for more equal parenting time for me, again. After a bunch of back and forth between the lawyers, my lawyer told the judge, "We're seeking a certain level of fairness that has been absent." And then the judge lost it. She got really angry at my lawyer and started yelling at him, saying, "There has been no lack of fairness in this process from what I have observed with respect to how I see the parties." But she never talked about how she saw the parties, or what she thought the facts were. She ran away from providing any justification or intelligent thought. So we were told to come back in March for another 10-minute court appearance to check on the status of the forensic evaluation. Well before the forensic analysis started, I had already gathered my facts and evidence. It took me 10 to 30 hours a week of work on top of my day job. We met the psychologist about 7 times each for a total of maybe 8 hours each. There was one occasion where the mother and I jointly met with a forensic psychologist, so the psychologist could see how we interacted together. During my one-on-one meetings with a forensic psychologist, I presented all my stories and evidence as to why I was a better parent, and about the mother's violence. Also, two of our couples therapists and psychologists, whom we met with in real life before court, they spoke to the forensic psychologist as well. In court in March, we discussed that the forensic report wasn't complete, but each parent had met the psychologist. We asked to start setting trial dates, but the judge didn't want to set dates until the forensic report was complete, so that only delayed the start of a real trial. My lawyer and I didn't ask for more parenting time because we got yelled at for doing so last time in court. In April, we had another 10-minute appearance in court where we received copies of the 40-page final forensic evaluation report. Neither parent or lawyer had a chance to actually read it in any depth, so there was no discussion about anything in the report. The lawyers just said they wanted a chance to review the forensic report with each parent, and then see if, based on the findings, the parents could mediate a resolution on custody without going to trial. In July, we went to court and told the judge that we needed to set trial dates, because we had already been at this for a year with no resolution. We told the judge that the parents started working with a third-party mediator to settle this, but we needed to move forward with a trial because settlement might not work. The judge asked each side to prepare a list of witnesses for trial along with an offer of proof, which is a brief explanation of why this person's testimony is relevant. And we had to submit this list on the next court date in writing to the court. The judge also decided that all 4 petitions for custody and an order of protection would all be wrapped into the same trial because the topics are totally related. And the judge decided that because the mother filed her petitions in court first, that means that she presents her case and witnesses first. That was good for me because I could disprove the mother's false statements if I went last. And the judge requested written summaries at the end of trial, which is like the closing arguments you see on TV in court cases, except that it's written. The judge set 3 trial dates for November. Yes, another 4 months away, because that was the earliest available date for court. Also, I lost my job shortly before this July court appearance. Recall that the entire existing custody arrangement was made only based on the fact that the mother was unemployed and available to parent. Since I was now unemployed, my lawyer asked the judge to give us equal parenting time, or to give me more parenting time than the mother. But the judge deflected that question to the mother's lawyer, who said they didn't agree to a change. And the judge, without any discussion, just decided she was going to leave everything status quo. I learned that the court could change the rules anytime they wanted. The court had decided it was a legitimate reason to give the mother custody because she was unemployed. But now that the father is unemployed, the rules change. And the court won't give the father even equal parenting time now that he's unemployed. So if we didn't fully recognize the judge was a gender-biased bigot before this day, we were 100% convinced by now. And then the judge set an appearance date in late September before trial. Between July and November, before the trial started, the mother and I met with a private mediator several times, but that totally failed because the court gave the mother all of the leverage in negotiating a mediated settlement by giving her primary custody for no reason. So mediation was doomed to fail. In court in September, we submitted our witness lists. Then the judge called the forensic evaluator on the phone and they scheduled dates for the psychologist to testify. The forensic psychologist testified once in November, once in January, and once in February. I was told that 3 times is a lot, and that it was weird that we called her on her 3 times. But since the forensic report had positive things about me and negative things about the mother, I needed to make sure the judge was fully aware of the findings. I had already learned that judges don't read the documents they're given, let alone understand how to analyze them. So my strategy was to ask the psychologist tons of questions on the stand to make her verbally repeat the things she had written down in her report. Basically, my strategy was to take the findings of the forensic report and shoved them down the judge's throat during live courtroom testimony for everybody in the courtroom to hear the forensic findings, so the judge couldn't hide from them in her final custody decision. The mother testified 2 days in November, twice in January, once in March, and once in May. This included my lawyer cross-examining her. So the mother took the stand 6 times, and recall that each day of testimony is around 2 hours in the afternoon. The mother had her witnesses testify once in February, once in March, and twice in May. You'll notice long intervals between testimony dates. These aren't done on consecutive days, but only when the court has an open time slot. The judge set about 3 trial dates to start. At the end of the last one, we needed more. But there are only 5 dates available scattered throughout January and February. At the end of those dates, we ask for more dates, but available dates are a month or more away, and that happened for another year. It's the most inefficient process you could imagine. The mother rested her case in May. I was called up to the stand that same day, and then one more day in May. I had 2 of my witnesses testify in June. I testified 2 more days in July, 2 days in August, 2 days in September. In November, I had my final witness testify, and I testified that day too. I also testified 2 more days in December. By this point, I had testified 10 times, but I wasn't done. That was only my direct testimony. I testified this much because I already figured out the judge was gender biased and incompetent. So my strategy was to drown the judge in facts and reality so she couldn't hide from the best interests of our son. If I cut my testimony short to end the trial sooner, there was great risk the judge would just ignore reality and then rubber stamp the mother. I had to break down the judge intellectually, emotionally, and spiritually. To save my son, I testified for 28 hours until I had broken down the judge's bigoted and incompetent thought process. From January until June, I testified 4 more times, including being cross-examined by the mother's lawyer. I chewed him up and spit him out. He got nowhere. Around June, we rested our case. The judge told us each to submit written closing arguments by September. In those 2 months, I wrote my own closing arguments. My lawyer only reviewed them. I wrote an 80-page summary where I completely destroyed any possibility the judge had of rubber stamping the mother for primary custody in the worst interests of the child. In November, we returned to court. The court clerk handed us a 25-page document. It said, "The court finds that the best interests of the child would be served by granting a final order of custody to the father. The father gets primary residential and legal custody. The mother gets visitation on alternate weekends. The mother committed domestic violence against the father, and so the father gets an additional 2-year order of protection against the mother. The mother's order of protection against the father is not credible and dismissed." I was relieved that I won the custody decision at trial and didn't have to appeal the judge's decision. That could have taken another year or more. But I was also extremely disappointed because I proved what I said in my petitions 3 years ago. And if the court had listened to me on day 1, instead of rubber stamping the mother, we could have avoided spending $200,000 that could have gone to our son's college education. And I realized that if the mother wants custody, she can just go to court, no questions asked. But if the father wants custody, he has to go through an entire trial over many years. The gender bias is obvious. In the next episode, I'm going to discuss the pros and cons of this long trial timeline. In order for you to prepare your case, you need to understand what you have going in your favor and what you have going against you. These might be the darkest days of your life. They were for me. I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. If you like, subscribe, and share, it'll also help the YouTube algorithm get this message out to more fathers in our position. Also, if you find this information helpful and you want to support this channel so I can make more videos, please donate via my YouTube channel's About page. You can donate via PayPal or Venmo.